Okay, we are going to start the session 2. I would like to introduce the moderator of the second session, Ms. Park Sung-hee, who is PAC's commissioner. She got her PhD in communication from Ford University, and she is a professor of journalism and communication at Ewha Women University. Now, she will be the host for the session 2.
Well, good afternoon, ladies and gentlemen. Did you all have a nice lunch? I hope you did. We'll begin our second panel under the theme of the Press Council and Ombudsman and the new solution of ADR. My name is, as introduced, Sung-hee Park. I'm one of the commissioners here at Press Arbitration Commission, and also I teach journalism and communication at Ewha University. About 20 years ago or so, I was also a journalist myself. But before we open up, may I ask you to turn off smart everything, like cell phones and all the electronic devices? In case you have urgent matter, you can put them into a vibrating mood. And not only do we have a freedom of expression, we also have the right not to be interrupted. And all of us here in this room, we deserve undivided attention. So now, as a moderator, I'd like to give you a brief overview of this second session. As Chairman Park Yong-sang already highlighted in his welcoming remarks this morning, Korea is known to be the one and only country that runs mediation system when resolving the disputes over news reports. Most countries are operating press councils or ombudsmen for responsible news reports. Last night, during the reception, Dr. Yeom Gi-ho, a big name in the field of press law, said that our Press Arbitration Commission is an influential organization that has a very unique place in the world. Throughout this session, we will explore these systems. You will hear actual voices of experiences sharpened in the field that run various variations of press dispute resolution systems, such as press council, ombudsman, and mediation and arbitration. We'll also have a chance to find out how unique the Korea system of press mediation and arbitration really is. So for those of you who traveled halfway around the world to attend this conference, you'll have your airfares worth to learn about our Korea system inside and out and backwards and forwards. Well, I believe our three speakers' expertise coupled with experience in the field will give us a great insight and inspiration as to how we should assess and situate our own system in light of the interplay between press freedom and responsibility, and also what kind of challenges or changes that we will face in the future, especially in the era of technological advances. Well, as a matter of housekeeping, I'd like to briefly mention how I'm going to run this session. Well, each speaker will have 20 minutes to present, and at the end of each presentation, we'll take questions from the floor while your memory is still fresh. And when you raise your question, please state your name and affiliation. And after 3 presentations and 3 Q&A sessions, we'll come back to our 3 panels to exchange their views and ask questions if they have any toward each other. Well, we've agreed upon this procedure last night over the dinner table. So this way, the audience would have a chance to see the dynamics among different systems, and hopefully will find some answers to the questions they did not think of. So much for the opening remarks. I now would like to introduce 3 panelists and their major topics. Our first speaker from left is Miss Christiana Chelsea Chan from Indonesia. Miss Chan, please raise your hand. Okay, the only lady up there. She is a legal expert in the Working Group of Law and Regulation of the Press Council of Indonesia. And she was a former media law consultant in the UNESCO Office of Myanmar. She is also former executive director of Indonesia Media Law and Policy Center. She flew 6 hours from South to talk about Press Council of Indonesia. Our second speaker is Mr. Tarmu Tamart, from Estonia. He is media ombudsman in Estonia Public Broadcasting Company. He is also the president of the Organization of News Ombudsmen and founding member of Estonian Press Council. He flew 9 hours from North to give us a talk about the role of ombudsman in media accountability system. Our third, but certainly not the last speaker, is Chung Jun-young from Korea. He is presiding judge of Patent Court, and he served as head commissioner in our Press Arbitration Commission. And he will give us a complete overview of Korea's system. So to save some time, I'm going to start from Ms. Chan, please.
Thank you, Professor. It's very difficult for me to speak because we have a very diligent professor among us here, and on the other side, we just practicing the academic background in terms of the media society. Well, anyway, allow me to introduce. I'm from Indonesia, and as you can see, I'm wearing one of my traditional motif batik to introduce that Indonesia also very rich in culture. And I wish that one day our very kind host, Press Arbitration Commission of Korea, have sometimes to visit Indonesia. And also our overseas friends from across the world, Israel, Africa, and also European, willing also to come over to Indonesia. It's not far, 6 hours, as our moderator mentioned. Thank you. I will try to keep with the 20 minutes as allowed by the moderator and agreed among the speakers. I try to share with you in 3 parts of presentation. The first part will be a background or historical background, what it is now the Press Council in Indonesia. We have a very dynamic political situation previously, and the current president is the 7th president, Joko Widodo. But before him, we had, I said in the past tense, we had 2 orders. Governmental system. The previous one we called old order, and the new one we called new order until the presidency of Suharto. And both era established so-called press council, but in a different system of work. Under both presidents, we had close press council system. Why we call close? It is because the chairman of the press council at that time was appointed by the government. It is totally different what we have right now, the current system. Even though the previous one also established by a law, a legislation passed by the parliament, but the current one stated clearly that the membership of the Press Council is no longer consists of the government representative, no longer consists of the parliamentarian representatives. It is only for journalists, the media companies, and high-profile society who can be nominated and elected to be member of the Press Council of Indonesia in terms of independent press council. That's a brief background of the current press council system. And the differences between the previous and the current one according to the law, the existing law, the Press Law number 40, 1999. The rule of the Press Council also providing different rules. Before, there is no statement that the Press Council will become a guardian of press freedom. Current press law, number 40, 1999, it is clearly stated that the existing independent press council is a guardian for the press freedom in Indonesia. That's the total, the fundamental changes in our press system. The other new rule stating also by the law is that, excuse me, is that the journalist code of ethics usually, and I learned from many different countries, it is not stated in such legislation. But in our system, there is a very special article stated that journalists must obey journalist code of ethics. So one thing that usually outside the law, it is now inside the law system, inside the legal system. That's a very fundamental also for us, and it is accepted by the media society, by the journalists, by the media company, and by the parliament in 1999. All what I explained right now is actually in the book, which already printed nicely by the organizers. I try to attract your attention to me individually, not showing the presentation slide, because it is very challenging to have this session after lunchtime. So that's basically. And the second part of this presentation will show you or inform you that the existing member of the Press Council, which I mentioned before, coming from 3 different groups. They are, one, coming from representative of journalist organization, and then second, coming from organization of press company, and then the third one, representative from the high profile, which nominated by the 2 organizations mentioned before. And usually, the chairman of the Press Council, we have now 4 chairmen. The last 2 terms, we have retired Chief Justice become the chairman of the Press Council of Indonesia. And it is showing a very significant model and also a very significant influence in the life of media society currently in Indonesia. And beside the existing member of the Press Council, they are kindly receive support from the state in terms of budgeting, but it's not, it is an aid. It is not a yearly budget, state budget. It is an aid, so once the Press Council can decide themselves whether they will willing to receive or not receive, it's depend on the plenary meeting of the Press Council. That's in terms of financing. Also receive finance support from the media society. It's in a form of donation, which the amount, it's depend on each donation. And then the third sources of the financial is coming from the press company, which is also different amount decided by themselves. And it can be every year donate to the Press Council, but also can be every 2 years to donate to the Press Council. That's about the structure, the current structure of the press council. What happened with the activity itself? As I mentioned, the press council by law had about 7 mandates, 7 functions. Among them, the priority is to guard the press freedom and then to monitor, observe the practice of the code of ethics, and then to mediating the press complaint, the public complaint over press or news report, and then compiling database, establishing database by compiling the existing press companies around Indonesia. And then the other one is communicating fairly between the government and the society, also with the academic world. That's, among others, the existing Press Council of Indonesia. One of the colleagues during the dinner last night asked me how many public complaints received by the Press Council. And what I can share with you, between 2000 up to 2012, we received 67 in 2000. Until 2012, it increasing become 470 complaints. We have a debate internally. Is this showing the quality of the press by receiving so many complaints, or it is showing the increasing awareness of the public to use the existing system in the Press Council to settle their complaint, rather than using the court system by submitting civil suit or criminal suit to the court. And we are convincing that the statistic showing the increasing number of public complaints against the media company or against the journalists, or in terms of this news reporting, positively it is showing the increasing understanding of the public, from the high profile or even a common citizen, to use the existing press law in Indonesia, not using the criminal law as what it is before. And we are also willing to share with you that among about 70% out of 100%, of course, we settle in remedy. And they do not go to the court afterward. And also during the lunchtime today, we also received a question whether it is allowed for the public, for the complainers still go to the court, even though the Press Council decided the decision. And the question is, we have a system that the public complaint, those who complain to the Press Council must sign a contract which provided by the council. This agreed not to go to the court after they settle their news reports complaint in the council. It is not violating the citizen right to go to the law, but still it's a choice, a free choice for them, whether they want to use the system in the Press Council or they want to use the system in the court, like that. So that's what happened currently in our Press Council system. And there is one more rule or task by the Press Council, which is, I'm happily proud to inform you that the International Federation of Journalists in 2008 providing the result of their survey among the existing press councils in the world, and they stated in that result that the Indonesian Press Council is number 2 after the South African Press Council, that promoting education for journalists is become one of the important tasks of the Press Council, which is maybe not have, the other Press Council do not have it. But in the Press Council of Indonesia, we do have that task to provide training, to provide media literacy, training for the journalists in every different level and every different platform, current platform, and also media literacy for the society, government, or even the prosecutors. Every year, every provinces in Indonesia. We have 34 provinces across the country, and we have 240 million people. That's a lot. And we have to, from time to time, renew our program, but still the existing media literacy program and training for journalists still exists. The other breakthrough, if I'm allowed to say so, we do have an MOU, Memorandum of Understanding, between the Press Council with the National Police of Indonesia. It is signed in 2012, and this existing Memorandum of Understanding become a very fundamental, significant help for the Press Council to limit the case in the court, because for those who do not want to use the Press Council system, and then they go directly to submit a file to the police, the police will not immediately use their criminal system, but they will come back to the Press Council requesting for a recommendation if this case related to journalistic aspect or non-journalistic aspect. The recommendation of the Press Council then become so-called their basic work, whether this case can go to the court or not, going back to the Press Council. So this is a very mutual understanding we have right now with the police, National Police of Indonesia. The other breakthrough is the Supreme Court of Indonesia willing to release so-called the circular letter of the Supreme Court addressed to Chief High Court and also Chief of District Court if in any way they receive a case regarding media. The judge must request an expert, a media expert, to the Press Council to explain how or what is the media work in front of the court before deciding the result or the ruling of the court. So that's a few things I want to share with the floor, and we are welcome to any questions or ideas to share with us. Thank you, moderator.
Well, thank you, Ms. Chan. I think she did a great job explaining the current status of the Press Council of Indonesia and how Indonesian press has transferred from the advocates of the government to the safeguard of freedom. And she also explained it very well about how it is functioning as a conversational body in the society between the legal society and the public and the media. And I didn't realize that she was having her own question and answer session during those lunch and dinner tables. But for those of you who didn't have enough, were fortunate enough to sit with her, this is your chance to raise your question. Okay, please, gentlemen.
Thank you. Two quick questions. In Israel, we have the same system of a three-tier system of, publishers, journalists, and members of the public, distinguished. In our case, it's 40% for the public, 30% for journalists, and 30% for the publishers. I was wondering what the percentage is like. What's the breakdown in the case of Indonesia? And I'm curious about your budgeting. You say you can get aid from the government, but you're not sure you're going to take it, and then you get donations, but maybe you don't. So how do you live? Thank you.
May I?
Could you take the questions all together and then you can answer at the end? Are you taking memos, right? Okay, the gentleman here.
My second question pertaining to the funding, as you raised, what are the powers of the press council? How you implement your decision? Secondly, powers to implement your judgment or decree. And secondly, you have said it is provided by an agreement. If a party approach a press council, then the party will not go to a court of law. What's about defamation, my personal right for damages, things like that? Then I will be. You can't avoid the damages. Does the Press Council of India, Press Council of Indonesia, has power to redress a case of defamation in terms of damages? I think like. And thirdly, how you implement these decisions.
Did you get the question? Okay, and then gentleman back there.
Thank you. I'm from South Africa. First of all, I would like to concur with you. We also have a system in South Africa that before we entertain any complaint, the first thing that we require from the complainant is to sign off a waiver whereby the complainant either choose to lay his or her complaint with us and not even go to courts after we have adjudicated on the complaint, despite the outcome of the case. And that waiver system has been working perfectly for us. But my question to you is, you spoke about remedies. What type of remedies do you as the council have? And secondly, I was smiling when you were speaking about the MOU that you have with the police. What if the case involves the police themselves? Because I know for a fact that we had to deal with a number of cases ourselves relating to the police. So I would like to hear your experience. Thank you.
So we have about
Can I answer first? The
answer for
three?
5 questions so far. So
Yeah.
will you please answer?
Thank you. Allow me to use this opportunity, very good opportunity, to introduce you to the member of the Press Council of Indonesia, which are among us right now. We have Mr. Imam Wahyudi sitting close to us. He is a member of Press Council coming from the representative of Journalists Association. And then Mr. Muhammad Ridho AC, he is member of Press Council coming from the media organization. And then Mr. Jimmy Silalahi from media companies also. And then Mr. Ray Wijaya from the media companies. So your question, Mr. Arik from Israel, we have 9 members only. 9% only, selected, elected. And it's agreeable, even though it's not stated in the law. In the law, it's only stated the organization who may nominate. But the number itself decided by themselves. It's agreeable once they elected. They release a statute that they can only, right now, they agreed to have 9. I don't know what happened. and after 2016, whether the new member of Press Council will agree to have more. Just for your information, the current member of Press Council all are gentlemen, none of them female. Sorry. So, but they are working very hard to contract me, so at least I'm female here. And the Secretary of Press Council also female. So that's, in terms of percentage, it's somehow 100% divided into 3 different kind of, yes, yeah. In terms of budgeting, well, it is stated in the law, in the press law, that the Press Council may receive different sources of money, budget. First, an aid from the state budget. Because it is an aid, so this is not obligation by the president or by the government to every year providing this budget. But anyway, every year up to now, since 2006, they are kindly providing it every year with different amount every year. So that's what happened. And it is coming from the account of Minister of Information and Communication, not from the Minister of Finance, not from Minister of Culture or Education, but it's coming from the account of Minister of Information and Communication. And beside the aid from the state budget, also it's stated in the law, the council may receive money from the society, from the media companies, any kind of sources which not break the law. That's the statement of the law. So, like the Asia Foundation once support the Press Council, providing the meetings when we want to develop the Journalist Code of Ethics back to 2006-2009. That's coming as a foreign budget, and it is allowed because we not receive the money itself, but we receive in kind, like the meeting packets, like that, sources of persons, like that. So that's in terms of budget. We receive also a donation from the journalist organization, like where Mr. Wahyudi come from. He come from the Indonesian Journalist Television of Indonesia. So the IGTI donate to the Press Council such as a remarkable amount of money for this for last year. But of course, it's depend on their own capacity, whether every year they can donate or not. And it is not obligation. So we are surprised, even to come here. MOU, I would like to answer that first from a question from our colleague from South Africa. The existing memorandum of understanding with the police is actually, yes, well, we receive complaint from public, from the police institution about news report on them. And then we call also the media to settle this complaint. But what we want, the basic idea to have this MOU with the police is actually to promote the existing press law. Because we want this law become lex specialist to be used in the media settlement, rather than having the criminal code practice every time in Indonesia. We inherited the criminal law since the colonial time from the Netherlands legal system. And what we learned back from the Netherlands, I think our colleague from Belgium maybe have understanding also about this system. We receive information, the criminal law in Netherlands is no longer applicable for defamation in terms of media complaint. they try to avoid that law to be applicable to media cases. But our society, Indonesian society and Indonesian political system and Indonesian legal system cannot just say like that. So that's why to break through between the idea of having press law as a lex specialis, the idea to have the press law as lex specialis is by having MOU with the police, the national police, that they willing to work by having recommendation from the press council to start the case. Without recommendation from the press council, whether this is a journalistic case or unjournalistic case, the press council will submit objection. So that's, I hope this answers your question. If not, we can do it again outside. In terms of remedies, well, in the press law, it is promoting, it is still stating that there is a sanction applicable for those who violating the right of reply, those who violating the article about censorship, or those who violating the article about reporting religions unbalanced, race, and things like this. Because we have so many different groups of society and different group of religions in Indonesia, so you have to be very respectful to these 3 specific articles. Once a complaint submitted by whoever to one media about news reporting on, we had before, one newspaper printing again, make a comment about what happened in Denmark, Danish cartoon before. And the chief editor of this newspaper was criminalized. But it is actually can be done as what expert witness at that time submitted to the court, that this kind of case actually can be settled just by the press council without having it settled in the court. So apology become one kind of way of settlement, and then right of reply, and then right of correction become one of them. Apology is the very strong one if you really make the mistake, and then right of reply, and then right of correction. I hope this also answered the question. And Pakistan, Chairman of Press Council from Pakistan asked the power of the Press Council of Indonesia. Well, it is when we first provide this kind of waiver statement to be signed, we understand that it is still the right of citizen to go to the court. And yes, in this situation, we experience different cases that even one who receive the settlement in the press council still goes to the court. It happened. But there is no punishment for them that the press council can punish them because they still go to the court. It has become an ethical insight personally, whether you agreed at first to use the system, but then you violating the agreement by still going to the court. But if they have a good faith, they will use the decision providing by the press council to become consideration for the court by the judges. Whether this is really actually a journalistic case, media case, which actually can be settled by the press council without having it in the court. So, defamation case still can be settled by the court. It is a choice. But the press council convinced that many, and it's showing by the statistic increasing media settlement in the press council, those who feel their name being alleged by the media without having settled in the court. So that's I hope answer your question. Thank you.
Okay, thank you.
Just one quick question. Yes, there's a lot. That will be the last question we'll take. Thank you.
Thank you. My name is Philip Hoets from the Press Council in Belgium. We have a similar press council with also 3 parties. But I would like to continue on the question that our dear colleague from Pakistan has asked. What is your power towards the media? Are the media obliged to follow your decisions, or is it a question of free will? And what if they do not follow your decision?
What is the mechanism of implementation of your decision? What is the mechanism under the law?
I guess the question is, how do you make the press listen to your decisions?
Yes, indeed.
And how do you enforce your...
Thank you. Yes. When the council have this mediation, and then it's agreeable to well, there are 2 different results actually. One is when both parties agreed to understand that, okay, this is my mistake, providing your name clearly, and it's defame your name, you feel this defame your name, I apology. But I do not have it is not by coincidence. And if the complainant can receive that explanation, this is what we call, this is settled by mediation, peace mediation. And both parties will sign the mediation paper, and this mediation paper result will be published by the media to announce to the public that they received this complaint and they acknowledge their mistake by violating the Code of Journalists, and then they willing to publish the ruling of the Press Council publicly in the same page where the previous news published before. Say it's in the first page headline, then they must publish it also headline. We do have a special guideline on right of reply. It must be done as quick as possible within the model of the media, model of platform. If it's a daily newspaper, the next day you must publish this once you receive it. And they obey. If your question is, do they obey with this? Yes. And the second situation is, if the case cannot be settled by mediation, the Press Council will release adjudication. Before that, the Press Council will have a plenary meeting studying clearly both parties' reason, explanation, and if it's clear actually violating the Journalist Code of Ethics, then the Council will publish its adjudication without having any other opportunity afterwards. Before, yes, but after, no. So the media, then we send the adjudication result to the media and to the complainers. And then the media, whether the question now is, do they obey with this one? It is a big question. And well, I have two different questions for that. for mainstream media in Jakarta, they are willing to follow the adjudication result. They are willing and they publish. But unmainstream media, which not in a good, not in healthy media company, they will take this unseriously, not seriously. Well, that's the answer.
I think she did her best to answer your question. Thank you, Ms. Chen.
Thank you.
And we'll move on to our second speaker, Mr. Tamarek from Estonia, and he prefers to give a speech in standing in a podium, so let's welcome him.
Thank you. Well, I thought I would do a little movement here in this post-lunch session. At least someone is moving around, and to keep you more alive and look in the other direction. Also, I've been working in the radio, and I continue doing my radio program on media ethics until today. So I know that sometimes it's good when you have something to say to stand up rather than sit down. But anyway, I will be talking about the role of ombudsman in media accountability systems, and also about the two tiers of self-regulation, basically. Press councils, voluntary bodies, of which we heard a moment ago, and the ombudsman, which work for individual media companies. Briefly about my background, I've been working in the media for the past 20 years. I started as a journalist right after Estonia, together with Latvia and Lithuania, broke away from the Soviet Union in 1991. And as soon as it was possible to start writing freely about things, I felt, oh, this is what I want to do. I was just a young person trying to see which career path to choose, and I decided now it's the time to become a journalist. So I've been working for newspapers, for radios, briefly for television, for news agencies, for the Association of Newspapers as a trade body. I was one of the authors of the Code of Estonian Press Ethics. I've been working as a trainer for media self-regulation in the Baltic region and also in some other places. But I ended up as ombudsman, and I will start with the ombudsman description, and then I will move on to the press councils. But before I do that, I would like to make one thing clear, that this is an international conference here. We are very gratefully hosted by the Press Arbitration Commission of Korea, and many people are from Korea here. But we have a lot of different experience present also in this particular hall. So the different models that exist, there's rationale and reason for all of those models. So no one model should be forced on other countries, or no one model should be considered better than another one. I will be talking about some of the examples in different countries, and then please let's view those examples as just examples from which we can learn, but we do not necessarily need to do it. The Organization of News Ombudsman, of which I am the rotating president at the moment, unites ombudsmen from 30 countries. But we know that there are media ombudsmen working in more than 30 countries, so not everyone is a member of the ONO. So if it were a commercial station, then we would run a commercial now saying, join ONO if you are an ombudsman. The ombudsman in the, which belong to the organization of news ombudsman, mostly are called ombudsmen, but some of them are called readers' advocates or readers' editors or something like that. So this already shows that there is some flexibility and some difference between the ombudsman. Also, increasingly, the organization of media ombudsman has started accepting as members people who work as standards editors because some particularly public broadcasting companies, but also some other news organizations like big news agencies have started appointing such new people who are called editorial directors or editorial standards worker or whatever. And the idea is that particularly some big, and if they are public media organizations, then they need clear rules because the public has a lot of high expectations to them. So those standards, editorial standards people have also started joining the organization of news ombudsman. So the traditional news ombudsman works for one particular media company or a media group. And they act as the mediator between the media organization and the public. And they handle complaints from the audience, from the public, just as a press council would do. But a key difference is that ombudsmen also act on their own initiative. This is actually their duty. They cannot turn a blind eye on a problem that they see in their media organization. Many press councils, which I know, usually do not take up matters themselves, because if as a collective body, as a press council, you want to take up a matter yourself, you must have a very good monitoring system in order to make meaningful choices of whether you pick up a problem. If a member of a press council finds a very appalling article in a newspaper, he can't just go to work and say, okay, hey guys and colleagues, let's take up this matter. There's a problem, very big problem. Someone must complain to the press council. But ombudsmen must take those matters up. So if in my public broadcasting company, where we have 2 TV stations, 5 radio stations, and several online news portals in English, Estonian, and Russian, if I see a problem in the evening, then I have to take it up the next morning. I just can't ignore it. It didn't exist. So that's a particularity of the ombudsman work. Ombudsmen must take their own initiative as well. The question that I've been asked here also during the very fruitful lunch breaks and other breaks that we've had with colleagues is that how can you be independent as an ombudsman if you're being employed by the organization? And it's true that me personally, I'm getting my monthly salary from the same coffers where the journalists are getting their salary, whom I'm criticizing. So, yes, I have to be independent. It's in the statute of the ombudsman. The ombudsman should not take any orders from the editor-in-chief, although in the hierarchy of the organization, in the organization chart, at the very top there's the council for the public broadcaster, then there's the executive management, editors-in-chief of different stations, and so on. And the ombudsman is not the highest. The ombudsman is somewhere in a separate box. So it means that the editor-in-chief cannot tell the ombudsman anything about the possible criticism the ombudsman might have. It's in the statutes, and if they would do that, they will be violating that statute. So there is a guarantee, at least in the statute, that the ombudsman must be independent. And if he's not, then it's a problem, actually. Sanctions. That's a topical issue, of course, both for press councils and for ombudsmen. And the ombudsmen that I know and who belong to the organization of news ombudsmen, none of them can issue any other sanction than the typical soft sanction, which is the ombudsman writes a commentary or makes a public ruling or responds to the complainant saying there was a violation of media ethics. If it was a big problem, then the ombudsman recommends that the station issues a correction or issues an apology or something like that. The ombudsman cannot dismiss the journalist, but the ombudsman can, of course, make a recommendation again to the editor-in-chief saying, look, over the past year, this one particular station or this one particular editorial team has committed 4 serious media ethical mistakes. Do you think there's a problem there, editor-in-chief? And in most cases, the editor-in-chief agrees, and then it's up to the editor-in-chief what he or she will do with that. The ombudsmen, as a rule, are not regulated by law. They are created by the media organizations, particularly when it's a private commercial media operation. Again, I don't know a country where ombudsman for private media would be required by law. But the case is different with public media, mainly public broadcasting, public radio and public television. This is publicly funded, taxpayer money, and in quite a few cases, it's in the law on public media or public broadcasting. It's written that the station must have an ombudsman. But usually it stays as that, just a very brief requirement for the public broadcaster or public media outlet to have the ombudsman. It's not, the activity of the ombudsman isn't really regulated to a large degree in laws. When we think of the next level of self-regulation, which is press councils or media councils, as they are increasingly actually called in some countries, that they're being renamed from press council into media council as they work with all of the media, not only press, which kind of implies this is printed press only. The press council, as opposed to the ombudsman, is a collective body, nationwide body of self-regulation. And in Europe, which situation I know best, the vast majority of the press councils are voluntary self-regulatory bodies, which do not have anything to do with the legal requirement to exist, so they are not statutory bodies. They, of course, press councils also act as mediators between complainants and the media, and they do the same thing as ombudsmen do, which is to defend press freedom. In press councils, I think it's a good thing if it would include all the major stakeholders, that is the media on the one hand, with its representatives, and the public on the other hand. Although it's quite difficult to find the public representatives to the press councils, because the public is such a wide phenomenon from one end to another. So which of the various NGOs and sectors of life, would be entitled to have a limited number of seats on the press council? But I think this problem can be overcome. It depends on the country, of course. If the religion plays a big part, then it's clear that the organization of churches must have a place. If a country is not religious, like Estonia, which is one of the least religious countries, at least in Europe, then we don't have a representative of churches automatically included. But sometimes, by rotation, we include them as well in the press council. In press councils in Europe, usually the media members are in the majority. That is editors, journalists, and publishers and people like that. So media representatives are in the majority. And then the non-media sector has 40% of the members or something like that. So the similarities between press and media councils and ombudsman clearly are, once again, they handle complaints from the audience, and they promote quality and balance in journalism. But there are some things which ombudsmen do, but press councils usually do not. I mentioned it, one of the key differences already, which is that ombudsmen raise cases themselves, and they must do it. Ombudsmen also promote transparency in individual media organizations. This is something the press council cannot do, actually. Ombudsmen also explain how the media works by using specific examples. Ombudsmen are speedier. They do quicker work than press councils. They are closer to the media organization. They are within the media organization. And this is good, and this is bad. The fact that ombudsmen are close to the media organization is good in the sense that ombudsmen's rulings are clearly more trusted by the rulings of a press council would be if the ombudsman has a moral authority within the newsroom. It really matters if someone who knows how the newspaper is put together or who knows how radio TV programs are produced, and then he becomes an ombudsman, and journalists trust the ombudsman. And if the ombudsman says, guys, you made a mistake, and you have to acknowledge it publicly, then of course no one wants to admit mistakes, but then they will do it. So it's good that the trust could be built better way if an ombudsman enjoys authority and can show to the newsroom, we know how the media works. When a press council makes a ruling, I know it from Estonia, but also from the experience of many other countries. Sometimes the press council members just take the matter on a more theoretical level without paying attention to what the newsroom pressures are. And there may be some alienation of the media organizations from the press council and press commissions, because the press commission may seem to be working on a too high level, separated level from real-life journalism, which would create a situation in which some of the rogue media, some of the non-mainstream media may say, we don't need a press council. They don't know actually how things work in the media. So they're just a bunch of people from other ways of life whose opinions we needn't take into account. That's some of the things, differences between ombudsman and press councils. In some countries, the ombudsman works when as a first instance of contact for people who have a complaint. And if a person is not happy with that result that the ombudsman issues, then of course the person can move on to the nationwide collective body, the press council, to get the complaint handled there. My personal feeling is that the new challenges that the media is getting, particularly from the info technology field, means that to a certain extent the media's role is becoming bigger and the media's power is becoming bigger, as if a mistake occurs, we can do more damage to people. This is particularly true of online operations. If a mistaken report appears on late in the evening, for instance, on a TV news program, it's being copied, picked up, rather, let's put it this way, it's being picked up by other online news operations. By the morning, everyone knows the story, but the person has issued a very strong protest against the original report. Did someone work on the complaint at night between 10 o'clock in the evening and 8 o'clock in the morning, as a rule? No. But actually, this is pressure that ombudsmen are feeling more and more. Sometimes I feel that I have to work 24 hours a day. I get to work, or I open my email, these days on the smartphone or something. I see a complaint, someone is saying, I must get an immediate right of reply. That was absolutely wrong that you said last night in your news program. Now, the internet is full of this story. What will you do about it? Well, and why haven't you reacted? I sent you a complaint at 10 o'clock. No, it's 7 in the morning. So 8 hours have passed. You haven't done anything. Are you doing your work properly? So that's actually a pressure that particular ombudsmen feel. But increasingly, press councils are getting also quite nervous letters from people who complain and say, and why do you take so long? In the past, several years ago, we've been discussing at press council meetings in Europe whether 2 months is too long a period to handle a complaint. Then some councils have said, okay, we have shortened it to 1 month. But people are demanding even more from us, actually. So the new challenges are that, and if we add also the competition pressure, which means that media do not check information so thoroughly anymore, we have another aspect which makes media more vulnerable to public criticism, which brings me to my conclusion that the social media role is increasing, that's clear. But people who use the social media, as a rule, they are the media consumers. They are not able to replace media self-regulatory mechanisms. In order to have high credibility for the media, and in order to guard media against attacks, sometimes from politicians or governments or lawyers who think that the media must be more controlled because they can do more and more damage these days, I think there's only one fruitful solution, which is that we need to strengthen the self-regulatory systems. And the Organization of News Ombudsman can also offer assistance to any media organization which wants to set up the ombudsman position. Particularly, it's true for public media, public broadcasters, as I said. Next year, the Organization of Media Ombudsman expects to conduct the first course for new ombudsmen, a week-long course at the university in England, where we would be inviting people who have just started the work of ombudsman, so they would know how it is, and there would be practical sessions and so on and so forth. But regarding the collective nationwide bodies like press councils and press commissions, I think we need to strengthen them and to make it clear to the public that this is actually the way how the media can be held best accountable if the media acknowledge problems and mistakes, and if they trust their own self-regulatory bodies, which do not have overly big influence from the government, then I think this way we can make sure that we can defend freedom of the press and the authority of the media. Thank you.
Well, thank you, Mr. Tamar, for such a clear presentation and such a nice voice. And right on time. It's evident that you worked in a radio journalist.
Yeah.
Anyway, are you ready to take any questions from the
Yes,
floor?
yeah.
Okay. Would you raise your hand and state your name and affiliation? Yes, Dr. Yam?
My name is Q Yum. I am from the University of Oregon in the United States. Probably, I am not as intimately familiar with this topic as I should be as a First Amendment scholar. But from a broad perspective, there is no question about the necessity and the value and the significance of this kind of organizations. I am talking about organizations of news ombudsman and the press councils. But my question is whether press councils and the news ombudsman are more or less, how can I say, moribund or no longer existing in the United States, and what about Canada? What about some countries in Latin America? So they are some kind of viable option, or they are more or less irrelevant? That's my question for you.
Thank you.
Did you get the question? Yes.
Thank you for the question. Yes, in the United States, the ombudsman position is not so well off as it was. The Organization of News Ombudsman was created actually in the United States in 1980 and is still registered in the state of California. The executive director lives in Canada at the moment, and the rotating president is for this year and next year living in Estonia. The previous one was living in England, and the next one I don't know from where. So basically, it is an international group, but United States, particularly smaller papers, have suffered a lot financially, and they have done away with the posts of ombudsman. And also in some big newspapers in the United States, unfortunately, publishers have said just what I hinted at anonymously a few minutes ago, that they have said, in the age of social media, anyone can be a media critic. Why do we need ombudsman, and why do we need press councils? We don't need that. People will be expressing their critical opinions about the media immediately on Twitter and on Facebook. So the ombudsman is irrelevant, and the ombudsman position was liquidated. I think it's a mistake, actually. But on the other hand, we do have areas, regions where ombudsmanship is growing. In Germany, there's a chapter that was formed recently where the German-speaking ombudsmen are getting together. In Latin America, this is still a state-regulated system to some extent. But in several countries in Latin America, ombudsman positions are created at public broadcasting organizations these days. We may have our next conference, annual conference in South Africa next year. It's not sure yet, but we also want to invite some media organizations in Africa there who have expressed initial interest in creating ombudsmanship. Press councils do not exist in the United States, it's true, and in Canada as well. So they are big exceptions, actually. They have free media, but no self-regulation. It has evolved this way historically and culturally. But in Europe, press councils exist in most countries and are considered the norm. If you don't have a press council in a European country, then in media circles, your country is being looked upon as, is there something missing?
Okay, we have one or two more questions. Time for one more. Okay.
Yeah. I'm here, sir. How many ombudsmen in your country, how many media houses have their own ombudsman, number one? And secondly, you have said we have a power to take a notice, which we in judicial language say a suo motu notice. That power pertains to every matter which is unethical or it has some restriction. It must relate with the freedom of press. And thirdly, what should be your comments about qualification of an ombudsman? He must be an editor, he must be a journalist, or somebody else who should be. For an ombudsman, you are saying he must be an editor.
Did you get the questions?
In Estonia, there is only one ombudsman who is standing here today. So
You're looking
there
at one.
there is no physically present media ombudsman in Estonia at the moment because he's in Seoul. Some big newspapers in Estonia have expressed interest in creating the ombudsman office. I'm in my office for the 6th year. So and it was the first media organization in Estonia to create the Ombudsman institution. It doesn't come automatically, but I'm sure that it may evolve, particularly as media companies realize that the public is getting more angry towards the media sometimes. And because there are some sensationalist and very, very bad reports indeed. So, and particularly the big media companies are trying to think of ways how to make themselves more accountable. The biggest newspaper, daily paper in Estonia, recently started doing the editor's annual report, which is like a supplement put into the newspaper, detailing last year's work, saying what we did, what we covered, our best prizes that we got in journalism competitions, but also talking a little bit about the problems that we've had in the newspaper. So newspapers realize that there's a need to be more open and transparent, and to create the ombudsman position would be one way of making it clear. Yes, that media organization is very powerful, and they can, kill people, not in the direct sense of the word, but figuratively. But they are becoming more responsible. So it would be an advantage in the serious market, actually, to that media organization. Who should be an ombudsman and who should appoint the ombudsman? I think I don't want to praise myself at all, but just take my name away from my biography, and I think that's the answer. You must have a lot of involvement in the media before you become an ombudsman. Otherwise, your colleagues, journalists, would not be listening to you. They would be considering you as a legal expert. They can respect you from the legal point of view, but they know that you have never been working to a deadline. They know that you have never been running to get a story, and then you find different conflicting versions of a story, and you know you have to be on the air or you have to produce the story quickly. So if you haven't gone through that, then I don't think you can be an ombudsman. But of course you must study extra legal things and stuff like that, because increasingly everything is becoming entangled more and more, as we will be hearing later today about the right to be forgotten thing, which is kind of a legal thing but also a media ethical thing. So that's the combination that the ombudsman must fulfill. Thank you.
Okay, all right. Thank you very much, Mr. Tamarik. Thank you. Now that we'll move on to our third speaker, I'm very pleased to introduce Chung Jun-young, our presiding judge, and he's the one who will tell you all about Korean system. So I ask you to listen carefully. Thank you.
Thank you, Mr. Moderator, and my fellow speakers and distinguished guests. It is my great honor to be here, and I decided to challenge to present in English, even though I'm Korean. And I think this is my hard job, because this is my first time to present in English. Please cheer up. For your attention, I will give you some useful tips in Seoul. According to the claim of Dr. Wouter, a biologist at Maastricht University Medical Center, if you turn down the temperature of your house, you can lose weight. So, walking around in the street in Seoul, in this cooler and wonderful season is the best way to lose weight and get thinner. What I'm telling you now is not only about the press mediation and arbitration system in Korea, but also about my own experience with Press Arbitration Commission, as an arbitration commissioner and a lecturer of this commission's Mediation Arbitration Academy, and as a mediation administrative judge in Seoul Central District Court, which is the largest court in Korea, in 2010. And I think press mediation is very related to the civil mediation. So I'm starting with civil mediation in Korea because press mediation provided by Press Arbitration Commission is a kind of court-connected mediation. And I'm preparing a slide for understanding. Civil mediation. The left one is the civil mediation room inside court in Korea. This is the mediator. And Korean Civil Mediation Act was enacted in 1990, and when the judges who are presiding over the civil case can refer the cases to mediation. At the time, the presiding judge can mediate the case by themselves, and or they can send the case to mediation administrative judge. And in the presiding judge's mediation has been criticized because the presiding judge is wearing two hats as a mediator and decision maker. If the mediation does not result in settlement, the presiding judge should render a final judgment. So he is wearing two hats. During mediation, the presiding judge can facilitate and if not settled, can render a non-binding arbitration award. So the parties can object to the non-binding arbitration award. And this kind of mediation concerns the dilution of confidentiality rule. This is a very basic mediation rule, confidentiality. The mediation and the trial should be absolutely separated, but the presiding judge is providing the mediation. He is wearing two hats, and the confidentiality rule is diluted. And some presiding judges, is telling the parties to settle. So this is kind of coercion into settlement by judges. So even though the presiding judge's mediation has this kind of problems, over 90% of referred mediations is conducted by presiding judges. And then mediation administrative judge, this judge is separated from the presiding judge. He can mediate by themselves or distribute the cases to the other mediators. And the mediation is mostly facilitation of resolution of the case, and the confidentiality rule is mostly observed. And during the mediation, dialogue and voluntary settlement is encouraged. And even though this mediation has this kind of advantage, or just 10% or less of referred mediations is conducted by mediation administrative judges mediation. This is the situation until 2009. But after the 2009, Korean Supreme Court started the standing mediator system, and the Seoul Central District Court started early mediation and court-connected mediation in 2010. Standing mediator is a kind of higher mediator. Standing mediators are appointed by the head of administrative office of courts. He or she only handles mediation cases full-time inside the court. And he conducts the mediation by facilitation of resolution, and he can render a non-binding arbitration award if the case is not settled. This standing mediator system aims at the separation between mediator and decision maker. I think the adjudication of press council in Indonesia is very similar to the non-binding arbitration award in Korea. And then early mediation, when it comes to early mediation and court-connected mediation, Seoul Central District Court launched early mediation program in 2010. Before the early mediation system, judges ordinarily refer the cases after the first trial date or during the trial. But after early mediation, judges are highly encouraged to send the case to mediation administrative judges before the first pre-trial or trial date is noticed. And the mediation administrative judge distributes the cases to mediators, including out-of-court dispute resolution institutions. This is court-connected mediation. It includes the Korea Commercial Arbitration Board and Seoul Bar Association mediation centers. And now Seoul Central District Court has a dozen of out-of-court dispute resolution institutions. I, as a mediation administrative judge in Seoul Central District Court, strongly and actively involved in the launching these programs. And after 2009, the mediation referred to mediation administrative judges has been increasing sharply from 2,500 cases to about over 30,000 cases. It's a kind of explosion of mediation. And next one is press mediation and arbitration. Press mediation and arbitration is provided by Press Arbitration Commission. This is the arbitration room of PAC. Can you look around the arbitration room in Press Arbitration Commission? Not now? Not yet? Yeah. Tomorrow. It'll be a good chance. Korea Press Arbitration Commission, PAC, was established in 1981. I think it is different from Press Council. Korea Press Arbitration Commission is actually dispute resolution institutions, not the regulatory body. It provides mainly the dispute resolution, like mediation and arbitration. Of course, the commission serves as a monitoring body and recommend. The commission can give a recommendation to the press organization, but the main job is mediation and arbitration. So I think it is very different from the Press Council in Indonesia and in Estonia. And arbitral tribunal, Press Arbitration Commission has arbitral tribunals, so many arbitral tribunals. In 1981, 13 tribunals, but now 18 arbitral tribunals across the country. And one arbitral tribunal is composed of 5 or less arbitral commissioners. And the head of the arbitral tribunal is nominated by the Press Arbitration Commission chairperson, Mr. Park, from among commissioners who are judges or attorneys at law. And the arbitration commissioner is appointed by the Minister of Culture, Sports and Tourism. We have heard from the Minister yesterday's reception. And the term is 3 years, and we are appointed just once. And from among judges, attorneys at law, experts in the press. And there is a provision about the disqualification requirements, like public officials relating to the commissioner. And commissioners should perform independently and not subject to any direction or interference. This high quality of commissioners aims at the public trust in the press mediation and arbitration. And next, press mediation in general. I think press dispute involves 2 aspects. The one is freedom of the speech, and the other is individual's right to privacy. So mediation is suitable for the resolution of the press dispute. The parties should give collaborative efforts to quickly resolve the problem through dialogue between parties in interest. So during the mediation, the aggrieved person and the press organization's representative of the reporters should be present, and they talk each other and negotiate and discuss the possible resolution. So PAC press mediation is viewed as a sort of court-connected mediation. I will tell you why this is a sort of court-connected mediation in the next slide. Look at the process of the press mediation. Disputants can submit a press mediation petition in PAC, and then, and this is not a waiver to right to trial. No waiver, and this is only based on self-determination of the disputants. They can file a press mediation in PAC, or they can file a lawsuit. This is only the choice of the disputants. And the mediation cases are assigned into each arbitral tribunal. And mediation session is held quickly within 14 days from the filing and ended for just 1 or 2 months. So we can say this mediation is very effective and fair, of course fast. During the mediation session, arbitral tribunal helps the disputants discuss the issues and solve the problem. But if not settled, the arbitral tribunal can render a non-binding arbitration award, and the non-binding arbitration award has finality only if all disputants don't object to it within 7 days from the service of the award. And non-binding arbitration award has the same effect as the non-binding arbitration award rendered by judge during civil mediation. So it is kind of judicial settlement. What happens if the disputants object to the non-binding arbitration award? It is deemed as a lawsuit. So it is called a court-connected mediation. And the PAC provides the electronic filing about relating to press mediation. Look at the picture. This is the picture of electronic filing sites. If you have any question about the electronic filing provided by Press Arbitration Commission, visit people.pac.org.kr. Anyone who is damaged by the press reports can visit this website and submit mediation petition through the internet free of charge. So you will be very satisfied with this website because it doesn't charge you. So press mediation in Korea is becoming more and more convenient and faster. Look at the trends. Look at the charts. Press mediation cases also has been sharply increasing for 30 years. 44 cases in 1981 when the PAC was established. But now, the last year, 2,433 cases were received. So it's another explosion of mediation, press mediation. And the statistics shows us the efficiency of the press mediation in Korea. Efficiency can be decided by the settlement rate and the rate of moving to court. So more than 70% of the cases filed with PAC was settled. And just less than 10% of the cases moved on to court. But there is some criticism about the press mediation from the academics and practitioners. It's about the monetary recovery. Low monetary recovery is mentioned. In court, $7,000 in press damage judgment is a median number in court judgment, but $1,600 is the median press mediation monetary recovery. But I think it's very natural because smaller recovery is because of the early settlement. So early settlement can stop potential increase in damage and can reduce time and cost. It is the very logic of the dispute resolution, and the PAC press mediation. In the press mediation, we can see the same logic. And then press arbitration. Arbitration is very different from mediation, as you know. Arbitration has finality. According to the Arbitration Act, it's because it's a consensual arbitration. It's very different from the non-binding arbitration award. Non-binding arbitration award is actually not consensual arbitration. So there is no arbitration agreement prior to the press report in conflict. It's a truth. No one can enter a contract about the arbitration before the press report. But parties can jointly petition a press arbitration in PAC prior to or during press mediation, with agreement where parties consent to the final determination of the arbitral tribunal. So in this case, the arbitral tribunal changed it to the real arbitrator. So arbitral tribunal can render an arbitral award with finality according to the Arbitration Act. Look at to the chart. Press arbitration also has been increasing. PAC started to provide arbitration services in 2006. It is rapidly increasing. 7 cases in 2006, but now 190 cases. And the next step is the PAC's involvement in conflict resolution education. PAC started to serve the conflict resolution education through the Academy of Conciliation and Arbitration. So I am one of the lecturers of this academy. This academy provides to journalists, secondary school teachers, law school students, public officials, and the public alternative dispute resolution, public conflict management, school conflict management, prevention of the press dispute, and community dispute resolution, etc. And it provides internship program for the secondary school students and support peer mediation in the nearby middle schools. Yeah, and it's time to conclude my presentation. This is the cornerstone of the Press Arbitration Commission. Did you see this? Yeah. I think press mediation is beneficial for both sides, for aggrieved parties, for the press organizations. Through dialogue, I think dialogue between the press organization and the aggrieved party is very important. Through dialogue, the aggrieved party can express their emotional damage and understand the value of the freedom of the press and accept apology from the press organization and can recover their damage. And through dialogue, the press organizations and reporters can feel responsible for unexpected results from press reports and can defend their sincerity in the news reports and find possible ways to restore the damage and prevent further actions like lawsuits. Yeah. I think public trust in press mediation and arbitration is up to how to administer the process of the mediation and arbitration and how to maintain the quality of arbitration commissioners. And press mediation in Korea has been quite successful in the perspective of a third persons like me. It's mainly because it's mainly through well-designed core-connected mechanism and resolving disputes effectively without moving to lawsuits. And the PAC's press mediation and arbitration is affecting other dispute resolution regimes, dispute resolution cultures in Korea. Thank you.
Thank you, Your Honor, for your such an organized and detailed presentation. I think they cannot wait to ask questions. All right, first.
Your Honor, you said that you are primarily concerned with resolving disputes. Who looks after media freedom in Korea? I know that in Israel, our parliament keeps trying to enact laws that would have chilling effect on the profession. And this is part of what we do, a major part of what we do. I mean, does the PAC have any role in this respect? Thank you.
Is the question related to that? Is it the question related to that?
Oh, I thought you were taking all the questions now, and he'll respond to all the questions.
Oh, no, let him answer the first question first. Okay.
I think it's not proper to answer these questions for me because I think there is another administrative body to secure the press freedom in Korea. And I think the press freedom in Korea is absolutely protected nowadays after 1980s people's movement. And nobody care about the freedom of the press, but in some instances, we are looking at the violation of the press freedom. But who can speak on behalf of me, related to the secure the freedom of the press in Korea? Any volunteers in Koreans? Professor Yam?
If you don't mind, maybe I might take a calculated risk of overexposing my ignorance of press freedom in South Korea.
Well, he's the expert. He's the right person.
Yeah.
Thank you.
But generally speaking, as Judge Chung specifically noted, since 1987, there has been no doubt. Oh, it's working? Oh, okay. There is no doubt, press freedom has extraordinarily expanded since 1987. And many people say, at least in South Korea, there is too much press freedom in South Korea rather than less. And there is extraordinary statement or testimony to the expansion of press freedom in South Korea. But the fundamental question is how to right balance. Always, as you probably know, in the United States, we have the First Amendment to the U.S. Constitution. That's beautiful. Congress shall make no law abridging freedom of the speech or of the press. But in 1946, Justice Felix Frankfurt, in the extraordinary case of Pennington versus Florida, basically said freedom of the press under the First Amendment doesn't necessarily mean there is no responsibility of the press. Freedom of the press always means responsibility of press. Simply because the freedom of the press means there should be responsible press, that is why framers to the U.S. Constitution did not have to believe the obvious. So that is what we talk about here. Freedom of the press is essentially relating to responsibility of the press. But the fundamental question is how to balance freedom of the press versus the right of the press. And there is the role of the Press Arbitration Commission. Maybe I might well be rambling too much. I have to stop here.
Thank you for answering for me. and I think, the freedom of the press in Korea is protected absolutely, and and some commentators say the press organizations don't listen to any words from administrative bodies. They can be only controlled and tamed by the court judgment, court monetary judgment. Yes. And next question?
Did you have
Yes.
the next question? Yes.
Thank you. I'll refer to you as my lord because we use the British system in South African law. My lord, two questions. The first one, on your slides, there's a very high explosion of number of cases in 2013. Could you share with us, in your view, what can you attribute to the reason for this high explosion? Secondly, I suppose this second question is informed more by where I'm coming from. I'm coming from South Africa, where not everybody has got a computer. Now, in Korea, you are using the e-filing system for your complaints. Is it fair to everybody, or people in the rural areas or outer areas? Do they have access to the computers, or what system do you use to accommodate those people? Thank you.
Yeah, the first question is the reason is I don't actually know the reason why the mediation numbers is so exploded, but I guess yeah, the supply create the needs. So the Korean judiciary provided the new mechanism of early mediation and court-connected mediation and standing mediator, and the active involvement of judges to render the cases to mediation contribute to the explosion of the mediation, especially in civil mediation. And when it comes to the press mediation, I think it is because of the public relations. I know the Press Arbitration Commission had endeavored to let the public know the press mediation or arbitration systems into the internet or into the news reports. So I think it is because of the efforts of the dispute resolution institutions. And the next question is about the e-filing. Korea is a very high developed, especially in the information technology. So every household has a computer. So I think it is not difficult to file press mediation in PAC through internet, and it is very convenient and cheap, no charge. Yeah. And I think most press mediation are filed now with PAC through internet, I heard.
Is there anyone who could add to his answers? Any participants from Korea? Yes. Would you like to answer?
No, maybe no. I'd like to add some kind of a footnote. I say at least in Korean society, especially since the mid-1980s, the right consciousness of South Koreans has substantially risen. So they are a lot more, conscious of right. So it means they are willing to challenge, the press organizations. And if they feel they are aggrieved or they are suffering from some kind of abuse of press freedom, they are willing to fight. So that's extraordinarily transformative development in Korean society. So, and also, some lawyers are willing to, represent, some Koreans, to fight against press abuse. And so I think that is sometimes quite relevant in terms of why there is more cases, I say, press arbitration, press mediation cases, and also press litigation. I understand there is more press-related lawsuits against the media organizations. There's also substantial, significant development in Korea.
Okay. Any other questions? Please.
Maybe it's just unclear for me, but the basis of your decisions, is it a law? So is it an act, or is there a guidelines, code of ethics also that is looked over by the industry, by journalists? Or if it's a law, is it somehow monitored by the industry, or is the industry involved in creating these standards?
I don't think so. It is the decisions or the non-binding arbitration awards or the settlement is basically upon the self-determination between the press organizations and the aggrieved persons. I think the press mediation and arbitration in Korea is genuine mediation and arbitration. It is not the administrative procedure. It is just mediation. It is not controlled and it is not influenced by the other parties, the other industries. Yeah.
Did that answer your question? Okay, thank you. Is there anyone else who has a question? Yes, please. Ladies.
Thank you for a very nice presentation. I'm Liliana Zurovac. I'm the Executive Director of the Press Council in Bosnia and Herzegovina. But I would like to ask, are the media obliged to publish decisions of the Press Arbitration Commission? And secondly, here in this act of press arbitration and remedias, it is said that there are actually some kind of penalties. In one article, it is said a person who falls under any of the following subparagraphs shall be punished by a fine for negligence not exceeding of 30 million won. So at our press council, we mediate between people and the media, and this is pre-court mediation process. So after our mediation, everyone is free to go to the court if he or she is willing to do that. But we don't have fines, penalties, or something like that. That's something what court can call upon it. So please.
Yeah, thank you for good questions. Yeah. If the case is settled, through the agreement between two parties and the finality of the non-binding arbitration awards, of course, the press organization is obliged to publish the contents of agreements. For example, the news reports on the corrected statement or contradictory statement, and if the agreement is related to monetary recovery, they should pay the money to the aggrieved person. It's an obligation, but this is totally civil obligation. It is not criminal. So if the press organization don't follow the agreement, they are not punished. They are just enforced by the Civil Execution Act in Korea. So it is very, I think there is a clear distinction between the civil matters and criminal matters in Korea. And the press mediation and arbitration is totally civil matters. Okay.
Okay, is there any other questions? I think this will.
Thank you for your
Thank
questions
you very much.
and enjoy the stay in Seoul. Thank you.
Thank you. Well, as I said earlier, we'll have another 15 minutes left, and we'll turn back to our panels for their mutual discussions and question and answer session. I think they wanted to have this kind of moment. So, would you first go, Miss Chen, or did you have any comments to each other about each other's systems and questions?
Well, it is a very good opportunity to listen directly from the president of the ONO, the Organization of News Ombudsman, and at some of the mainstream media in Jakarta, they also have their own internal ombudsman working internally to respond to common or public complaint directly to the newspaper. But in our experience, we receive a comment from the public who did that first before they came to us. And I don't know, I don't know the other experience at the organization, or they do have individually experience. One of the comments we receive is that the decision or so-called response from the internal ombudsman is unsatisfied, not directly answer the need of the complainers in terms of the violation of this journalist code of ethics. So how the I don't know, is there any similarity measurement among the ombudsman internationally, even though it's not member of your organization? Thank you.
Well, thank you for the question. Well, clearly, I don't think there are any two ombudsmen in the world who work exactly along the same ways. So there are differences between them, and particularly those who are not members of ONO, they may be sticking to different standards. But my first response actually to the question when you started was that, but isn't it the case that any person or organization who doesn't like, if we take a parallel from the legal world, who doesn't like the ruling of the first instance of the court, appeals it to the second instance. And they always say, I'm not happy with the first instance court, the judges are unprofessional, they may be corrupt, now I'm appealing to the second instance. So I think it's quite natural in a way that if a person gets a reply from the ombudsman saying, dear listener, reader, whatever the case may be, your complaint really isn't about what you say. We don't think there's anything wrong ethically here. It's a matter of taste or whatever, and unfortunately I have to turn your complaint down, and I hope you will have better luck with us in the future. It's clear that a person may just be angry at a response, and the response may be quite okay. And perhaps even at the press council, the same complaint would be rejected, but it may not be rejected. So it really depends, yeah. Thank you.
Any other comments or questions? Yes.
I ask questions to my fellow speakers about the mediation procedure. Ombudsman system and press council system serve the mediation function, even though your country doesn't have any specialized dispute resolution institutions like Korea's PAC. But I want to know what the mediation procedure is really like. So, are the press organizations representative or the news reporters involved in the mediation procedure provided by ombudsman or press councils?
Well, the press councils that I know, so that most of the press councils in Europe, for example, and ombudsman, they work on the principle that they get the complaint and they first try, both the ombudsman and press council, they try to put the complainant in touch with the editor or the journalist responsible for the story. Perhaps the two can settle the matter amongst themselves. Perhaps sometimes it's just a small apology that is required by the reporter about the small mistake that he made in the article. And then the person who complained is satisfied and leaves the matter there without taking it further. So in press councils, usually the person who gets the complaints does not put it into the machinery immediately, but, you know, we have a complaint, we will have a session to discuss it. No. First, they will get in touch with the person saying, have you been talking to the editor-in-chief? What did they say to you? Perhaps you could talk again and point out that something like that. So if that doesn't work, so it's an informal kind of mediation that goes on, and if it doesn't work, then of course the press council or the ombudsman will have to take up this matter in earnest, like registering it, complaint number, so and so, and who will give their responses, and then the work starts on making a ruling on it. And in that case, you have the opinions of two sides like a judge would have in front of him, but it's on paper-based in most cases, not physically inviting people. Some press councils invite physically people present as well, but in most cases it's on documents-based thing. There's a complaint file, and here's the response of the media organization, and then the ombudsman is reading this, or the press council is reading this, is discussing and passing a ruling. So that's the description of how the mediation is done in an informal way before it actually gets to passing a ruling by the press council or by the ombudsman.
Okay, thank you very much. Well, I was sitting here and listening to our presenters, and got me thinking again how important and valued the freedom of press is, and how we strive to preserve that right along with the responsibility, regardless of our differences in our political system and our status in press freedom. And I hope this session has served you well as an inspirational journey about the topic. And I would like to close by thanking our panel for the excellent presentation and contributions. And my big thank you to the audience for joining our excellent panel. Thank you very much.